They've all filed these motions to try to, they've framed them in various ways, but the basic gist of these motions is they're asking the state court judge to stay the proceedings in state court. Mark Meadows has also filed a motion to sever his case on grounds that, if the case is removed, it might bring all of the defendants into federal court. So he tells the judge, you might as well sever me now, because then that way, if my case gets removed, it's just me.
I'm Benjamin Wittes, and this is the Lawfare Podcast, September 9th, 2023. It's another episode of our weekly live stream series, Trump's Trials and Tribulations, which take place live on YouTube each week, Thursday afternoons at 4 p.m. Eastern Time. This week, I was joined in the virtual jungle studio by Lawfare senior editor Roger Parloff and Lawfare's legal fellow Anna Bauer to talk about the latest events in Proud Boys sentencing and in Georgia. We talked about the hefty sentences that Enrique Tarrio and other Proud Boys received this week in federal district court in Washington. We talked about how these sentences compare to Oath Keepers and to other January 6th perpetrators. And we talked about the machinations in Georgia, removal, immunity, severance, and all the other stuff that is going on with poor Judge McAfee trying to deal with a 19-defendant trial. It's the Lawfare Podcast, September 9th. Proud Boys sentencing and Georgia wrangling. Roger, get us started. We had a string of sentencings in Proud Boys cases. You were not at the sentencing, but you did sit through the whole trial. Tell us about the sentencings and how they compared to what you expected.
They were heavy sentences. I expected heavy sentences. They were a bit heavier than I expected. We had a 22-year sentence for Enrique Tarrio, the leader of the Proud Boys. That's pretty remarkable. It's, that the maximum for seditious conspiracy is 20 years. So to get a 22-year sentence, you need to run sentences concurrently. That's 4 years more than Stuart Rhodes got, for the founder of the Oath Keepers. And then the second defendant, Ethan Nordine, got 18 years, the same as Stuart Rhodes. Joe Biggs got 17. Zach Reel got 15. And Dominic Pizzola, the fellow that broke the 2 panes of glass, as you've seen, the first panes of glass that allowed the first rioters to get into the building, he got 10 years. So these sentences, these 5 people, well, at this point, there have been about 1,150 cases brought, and 4 of the 5 top sentences are Proud Boys. 5 of the top 10, 7 of the top 10 are Proud Boys or Oath Keepers. That said, they were years below what the government asked and years below their sentencing guidelines. So it's conceivable that the government might appeal these, even as it appealed the Oath Keeper sentences. But I think that would be silly. These are very heavy-duty sentences.
I will bet you lunch at a restaurant of the winner's choice that the government appeals this, because the higher you push the ceiling, from the prosecutor's point of view, and Enrique Tarrio is the ceiling, right? He's leadership cadre and he's violent, or at least he supervised violence. Whereas Stuart Rhodes is leadership cadre, but as you've repeatedly pointed out, the Oath Keepers were kind of more talk than anything else. The Proud Boys are the real deal. So the higher you can push Enrique Tarrio's sentence, the higher all the other sentences level up. Am I wrong?
That's right, except that we really, at this point, I think we've hit the top as far as we're, expecting any of, as far as the blue collar defendants. And there's nothing coming down the pike that's going to compare to this. So, but it does raise interesting questions about if Trump ever does go to trial in one of these January 6th cases and is convicted. The federal sentencing analysis would be different, but as we've seen, the judges don't necessarily give a lot of weight to the sentencing guidelines, and it's hard to see how he wouldn't get more than these guys since they were all there for him.
Yeah, although he is charged under wildly different laws than they are.
Mm-hmm.
So I'm interested in the relative disparity between these guys and the Oath Keepers. When the Oath Keeper sentences happened, your instinct was that they were pretty reasonable and that I believe it was Judge Mehta, right?
Yes.
Was making pretty reasonable distinctions between them, and that his departures from the sentencing guidelines and from the government's requests were pretty sensible and reasonable in your view. This is a different judge, Judge Lynch.
It's Judge Tim Kelly.
Tim Kelly, sorry.
And maybe it's worth mentioning that he's a Trump appointee.
Appointee.
We usually try not to mention that, but here it sort of, anyway.
Worth mentioning. He's a Trump appointee, and he is also somebody whose management of the case, as I recall, you were not especially admiring of.
Well, I admired that he really tried to be fair. He really tried to get things right, but he deliberated a long time on a lot of issues, and he let the lawyers go on and on and on. That I would quibble with. But as far as the crucial things, you want from a judge, trying to get it right, trying to be fair, I thought he was good.
So looking at the Proud Boys and Oath Keeper sentences together, you have a general pattern of sentences coming in well below the guidelines, well below the government's request, and yet nonetheless pretty stiff and serious relative to certainly anybody else who's been charged and convicted. When you look at these Proud Boys sentences next to the Oath Keeper sentences, does it look something like justice to you, or are there standout cases who should have gotten more or less?
Yeah, no, it makes sense to me. And the Proud Boys case sentences are heavier than all of the Oath Keepers, with the exception of Rhodes, and that's as it should be. The sense was that Rhodes was much more culpable than the others, who were basically all just followers of him, sort of enamored of this charismatic guy, at least for a while, and mesmerized and bamboozled to some extent. And in fact, some of the lower level people, some of the people in the stack, not the seditious conspiracy people, some of them, well, one got acquitted and some got probation. You had some like 70-year-old people a couple that came in from Ohio, and, it just wasn't that serious. And what they did wasn't all that serious. But with the Proud Boys, these 5 at least, they were crucial, and the sentences show it. So it makes sense to me.
Make no mistake, we did this.
Yeah.
That's what I always, say in Lawfare's internal Slack channel when we raid a building. So you mentioned the 1,100 some odd now indicted cases. Oh, and we have some breaking news. Peter Navarro has been found guilty of 2 counts of criminal contempt of Congress for defying the January 6th Select Committee. No surprise there, given that the judge rightly left him with very few defenses to posit, and there was no doubt that he defied the subpoena. So looking at the broad pattern of the blue collar cases.
I think that all of our grade school teachers would have said, no, he left himself no defenses.
Good. The judge clarified that he had left himself no defenses.
Yeah.
What can we say about the pattern here? It's a pretty large end set at this point. What can we observe about it? How done is it? How many more cases are we expecting? And what are your observations about the 2.5 years of work at the blue collar end of the January 6th prosecution space?
Well, it's been extraordinarily successful and pretty comprehensive, and it's going on. I mean, there are new arrests still. I don't know how many they plan to continue to do, but we did get a new arrest for one of the people that attacked Officer Fanone, and this week. So they're really trying to track everyone down still, but I assume it's slowing down. I see some of the numbers falling as far as the number of people on the all points bulletin or whatever it is. There used to be 350 people they were still looking for. I think it's come down a little.
We've discussed at great length over the years, and it is now years, the fact that there was this missing layer, right? There was a kind of pretty and increasingly comprehensive set of prosecutions of people who were on the ground January 6th, and there was kind of nothing at the political level. Now we have state prosecution at the political level. We'll get to that in a moment. We have federal January 6th prosecution. We have Mar-a-Lago, though that's not quite related. How does the larger picture look to you?
It's an enormous load off my mind, until some of these other people had to at least answer charges. It all felt like a farce. You can't go after 1,100 people who were following this guy and who were tricked by all of these other people. And the judges felt it, and the jurors felt it, and we felt it. And many of the judges have made references over the years. I think at least 9 have referenced that, these are pawns that we're looking at. They committed crimes, but when all is said and done, this wasn't their idea. And it is a great relief that at least these higher ups are going to have to respond to what they did. They're going to have to answer. I don't know how it will come out, if they'll be exonerated, fine, but they will have to come forward and answer.
And do you think that, like right now at the federal level, it's a weird mix, right? You've got the comprehensive lower level on the ground January 6th. You've got Trump and nobody in between, right? Because the whole senior management and middle management layer, all of whom are indicted in Georgia, or most of whom are indicted in Georgia, are all unindicted co-conspirators at the federal level. Does that bother you as a missing layer, or is that fine if they answer for it in Georgia but are unindicted co-conspirators at the federal level? Or does it need to fill in that there needs to be like the you can't have the top of the pyramid and the base of the pyramid, but this missing pyramidal Jeff Clark, John Eastman, Rudy Giuliani, Sidney Powell layer in the middle?
Well, I don't know how it's going to play out. At the moment, I'm content, because this format of one defendant and you go at him and is obviously so much more efficient and workable than 19.
I wonder why you used the number 19, where that just pulled that out of the air, Rod.
Yeah. And yes, to some extent, the fact that these people, Chesbrough, Jenna Ellis, all of these people are caught up in Georgia. Somebody is taking them seriously. That does, to me, seem adequate, given it's urgent that time is of the essence. Let's have a streamlined case that goes at the guy at the top. So I'm okay with that. I don't know that that's really Jack Smith's plan, or whether tomorrow he'll indict 18 others. But it's a very I just don't. It's so unwieldy. I remember. I'm old enough to remember the Pizza Connection case, which I think started out with 22, and 2 pled guilty and 1 got murdered. So I think it ended with 19. It took 16 months to try. And I think the Second Circuit said later on in a different case, no mas, we're not going to do that again. If it's going to take more than 4 months, you break it up. And we saw the Oath Keepers was actually a 9-person indictment, or more than that. Some pled guilty, but they tried it 5 and then 4. And then there were some other people left over. But 19, that's, I'm not familiar with Georgia practice, but that just seems unwieldy to me.
All right, so let's talk about, that's a great transition to the unwieldy state of Georgia, where Anna is joining us from, with a much more traditional background than last time. So, Anna, we have 19 co-defendants. 2 of them want early trial, but they want it separately from each other. The others want to be separated from the 2 of them, don't care if they're tried together or separately, but they want to push it off as long as possible. And the government wants to try them all together, all 19, and is fine to do it, it says, in October, so that Mr. Chesbrough and Ms. Powell can be tried in compliance with their Speedy Trial Act requests. So this sounds like a LSAT logic game. Is there any way to design a trial plan so that everybody gets what they want?
Well, no, especially because some of them want to not be tried with anyone. And you're right, it is like an LSAT logic game. There was a hearing.
Chesbrough will be tried with so-and-so, but refuses to be tried with so-and-so. Trump wants it trial put off until the sun supernovas, but, Powell wants to be tried yesterday.
Right. No, exactly. And there was a hearing yesterday on this very subject, where the judge tried to make an initial decision on at least the matter of Chesbrough and Powell. So Chesbrough and Powell had said that they wanted to be tried on their own. They didn't want to be with each other. They also didn't want to be with any of the other co-defendants. They're the only 2 who have filed these speedy trial demands, which requires the prosecution to basically try them within 2 grand jury terms, which in Fulton County is about 4 months. So I think the deadline for Fani Willis with Powell and Chesbrough is November 3rd. They have to initiate the trial proceedings in order to avoid dismissal of the charges against Powell and Chesbrough because of these speedy trial demands. So the judge had a hearing yesterday. It was Judge McAfee's first outing in the case, besides, this initial kind of Rule 22 media hearing that we had a week ago. But he ended up deciding
that... He looks, by the way, Judge McAfee looks like he may be about to have his bar mitzvah.
He's 34 years. Yeah, he's 34.
He looks youthful.
He's very youthful, but he
seems really competent.
Yeah, he seemed, I mean, based on what I've heard, is that he's very competent. He seems, both defense attorneys and prosecutors seem to like him. He seems fair. He seemed very comfortable and assertive. He wasn't, even though he's only been on the bench for not even a year now, he just seemed very competent, assertive, like he really wanted to get things moving. So that was something that was an encouraging sign to see him on the bench. And it didn't seem like an Eileen Cannon situation where...
Really didn't.
Yeah.
Seemed like someone who knew what he was doing, knew the system, had his hands around the rules, and was only a little bit awed by the magnitude of the task in front of him, but not so awed as to be kind of paralyzed in a Lance Ito kind of way.
Right, exactly. And so the way that he decided to handle this was he just heard these severance motions from Chesbrough and Powell, the two speedy trial defendants, and he ended up deciding that he's going to basically force them to be tried together, even though that is, especially Ken Chesbrough, the last thing that he wanted. I
gotta say, I'm really sympathetic to Chesbrough on this. The last thing I would want is to have a co-defendant who is Sidney Powell. It's like, you got paired with a deranged, crazy person, and she's your only co-defendant. So you got to sit next to her for 4 months and just hope that the jury is going to be like, well, he's not her.
I mean, that was basically their argument, right? They were like, his Chesbrough's attorney said, Your Honor, you and I both know that Mr. Chesbrough sitting next to Miss Powell is going to be prejudicial to him. So that was basically the argument that they made, is that Chesbrough being tried along Sidney Powell is just going to spill over and affect him and prejudice his, ability to be fairly tried. The judge, however, wasn't buying that. I think the state made a lot of compelling arguments that because this is a RICO case, all of the evidence that could be brought in against any of the co-conspirators could likely be brought in against Chesbrough himself, because the way that RICO conspiracies work is that you're basically being held liable for all the acts within the enterprise that were committed as a part of the racketeering pattern. So, and the judge decided that was convincing. And he said, I'm going to put Powell and Mr. Chesbrough together. But what he didn't do is make a decision about all the other 17 defendants in the case. So it seemed like he was really skeptical of putting them to trial on October 23rd, but he allowed the state to, say, we want to do more briefing. And he said, okay, that's fine. Next Tuesday, have your briefs in. And it seems like he's going to make a decision fairly soon on what to do about all these other severance motions that have been coming in. And after that hearing, we saw Mark Meadows was motioning to sever, and I think David Schaefer. So we've had a few more severance motions that have been rolling in on the docket. And
just to be clear, the theory of those severance motions is not, we don't want to sit next to Ken Chesbrough and Sidney Powell. The theory is, there's no way we can be ready to go to trial on October 23rd. If they're going to trial in October, count us out. Is that
right? Some of them, that is the argument. That's Trump's argument, is that there's no way we're going to be ready. His attorney, Steve Sadow, who is new to the case as of a few weeks ago, has a trial which actually is before Judge Eileen Cannon in federal court. So he has a separate trial that's happening. I believe it's in early October, maybe late September. But in any case, it is between now and the October 23rd trial. And he basically is just saying, Judge, there's no way I can be ready in time. This is a huge RICO case. And I think to that end, they kind of have a point that this is a huge RICO case, and defense counsel, is going to need time to go through the 2 terabytes of evidence that the district attorney's office says that they have to turn over in discovery. On the other side, you could argue, well, they've known this was coming for, a year now, and a lot of this evidence likely isn't new to them. But I think that a judge is going to be very reluctant to say to, 17 defense attorneys that, hey, you got to be ready by October 23rd when, they're all going to have various pretrial motions. The judge is going to need to have time to consider those and write opinions and orders on them. And this isn't, federal court where he has like 4 different clerks who can, work around the clock to get these orders out in a really quick fashion. He's doing a lot of this with, one clerk, and that things just kind of work on a slower pace in state court than you would in federal court, I think. So there's a lot of factors here.
What do you think the chances are that the government files its briefing on Tuesday? Judge McAfee looks at it and says, you know what? I think we can pull this October thing off. I'm not severing these other cases, and you should all be ready to go to trial in October.
I mean, I think it's pretty close to zero. He, like I said, he was very skeptical. The other thing, too, I would mention is it's not just that some of these folks want to be prepared for October 23rd. The removal aspect is something that Judge McAfee mentioned.
Yeah, we're going to come to that in a minute. Hold the removal thought.
Okay. So, yeah, I mean, I guess I'll hold the removal thought, but he was very focused on how removal would impact what's happening with the trial. And so I think what we're going to see is a big group of 17 later on. And then it seems like the October 23rd trial with Chesbrough and Powell is going to happen. So that's pretty exciting.
Roger, you're shaking your head. Is that because you doubt that the October 23rd trial is going to happen, or because you think it's insane?
I'm just amazed that even, 2 people can go to trial that quickly. But
I want to make the argument that this is a smart move by Chesbrough's lawyers. Chesbrough is accused taking the acts that he committed himself. He's accused of basically writing a couple legal memos, admittedly on an extravagant legal theory, and in taking the most modest steps to get these implemented in Georgia. Is that a fair summary of what he's accused of? And so I guess my question is, if you have to try Chesbrough by himself, that actually, or with Sidney Powell, whose conduct is unrelated to his. She's involved in all kinds of other stuff, Coffee County, crazy screaming White House meetings, try to appoint her a special counsel. She's got her own problems. But it seems to me, if you're Chesbrough's lawyers and you're just looking at what he's alleged to have done, not that easy to show that he's part of a larger criminal enterprise. He's a Wisconsin lawyer who does some work for the campaign and has this batshit crazy idea and advances it. He's not the guy who implements any of it. And so it seems to me if you lop him off from the larger story and you say, what did he do? I kind of like his chances before a jury, actually. He's a guy he was a nerdy lawyer who had a weird idea, and some people ran with it. He didn't really have much to do with that. So my question is, are his lawyers here just being smart? Get him as alone as you can, as early as you can, and make the government answer the question, what is it that Ken Chesbrough is alleged to have done? And you got to talk about him because, you can't talk about the other stuff because the jury's going to not really, I know the stuff is admissible against him under a racketeering theory, but eventually the jury's going to convict him based on his own conduct. And I do have this instinct that the government here has sort of imagined a more comprehensive story then you're going to be able to tell if one of these defendants is sitting there alone and it's not Donald Trump. What do you think?
I mean, I'm in agreement that I think it's a good move on the defense attorney's part, because I mean, I think the first reason why is just because it is a way to almost guarantee that your client gets severance from a lot of these folks, because I think maybe what they didn't expect is that anyone else, and especially Sidney Powell, would also file a speedy trial demand. I mean, I think you're right, but I do wonder how Sidney Powell, even though everything that she did is a little bit more, attenuated from what he did, prosecutors are going to make the argument that it was all as a part of the conspiracy to overturn the 2020 election. And I do think that it's going to be worse for him having Sidney Powell in that trial than it would have been if, as you've described, if it's, just him. So
I just think it's hard. If you focus on the question, when did Ken Chesebro join this conspiracy? Assuming there's some racketeering enterprise, there has to be some point at which you said, okay, I'm signed on. I'm doing this with you. And I do worry a little bit from the prosecution side that for some of these people, if you look at their conduct in isolation, there is no point where they joined. They were just people who were working for the Trump campaign in one form or another, and who continued to do so after the election was over. And I think if you're Trump, the answer to that is, well, you didn't concede defeat. You knew you had lost, and yet you persisted in doing this. But if you're some lawyer in Wisconsin, which is what Ken Chesebro is, and you basically write a couple memos that say, hey, I have an idea about how we might use fake electors to cover our asses in the event. I'm not sure did you join a racketeering enterprise at some point, or are you just, kind of sitting there shooting from your hip?
I mean, the top charge is still racketeering. And so they're going to have to prove the case. They're not going to do maybe a 4-month case against Chesebro, but
although they say they're going to do the same case if there's one co-defendant or if there's 19. They're presenting the whole thing.
And they have to. And so, for instance, with the Oath Keepers, like I said, they split the seditious conspiracy defendants into 2 because they were 9. And so they went with the 5 top defendants first and then the 4 next. And that was weird because you were trying 4 defendants in the second trial without Stuart Rhodes
being there, right?
And Stuart Rhodes is what the whole case is about. But they tried it, and the 4 in the second trial did worse. There were some acquittals on some of the conspiracy charges. Only 2 got convicted of seditious conspiracy in the first group. All 4 were in the second. And some theorize that it was worse not having the contrast between you and the really bad guy, the obviously bad guy. And so I don't know for sure. The thing with Chesebro that concerns me, as far as the prosecution case is, and it's all a matter of facts I don't know yet, I don't think any of us know yet, is how are they going to distinguish this from what happened in Hawaii in 1960? In Hawaii, as I gather, the contingent elector forms that were filled out did not say asterisk, this is a contingent elector form, contingent upon us winning litigation. It said, I am a duly elected blah, 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 which at the time wasn't true. At the time they weren't certified. And the theory was you need to do that, otherwise it won't be procedurally proper. And that's what, Chesbrough is going to say. And he's also going to go into this safe harbor theory. And it's all very academic. And they've got to show this is all a pretext and you knew it. So that's a factual maybe they have the goods, but
so that's actually a different way into the same point that I'm making, which is, right, if you're purporting to show that he's part of a racketeering enterprise or a criminal conspiracy, rather than showing that, hey, he's a nerdy lawyer who knows about Hawaii in 1960 and has this idea that you can replicate what the Democrats did. And you got to somehow show that he acted corruptly or made a decision to join this criminal enterprise. And I think that's just way easier to do if you've got 19 people, some of whom are crazy criminal types, literally knocking on poll workers' doors to intimidate them, than if you've got, he's the only one there, him and one crazy person, Sidney Powell, but their conduct had nothing to do with one another. That seems like it's going to be a weird case to try to prove. All right, let's turn to removal, because if Mark Meadows has his way, all of this is going to get nuked by Judge Jones of the Federal District Court in Atlanta, who is going to snap his fingers and say, I remove thee, I remove thee, I remove thee. And these cases are going to vanish and show up in federal court, at which point he's going to move to dismiss himself, and the federal courts are going to smartly salute. And so, Anna, where are we in the removal conversation? Is there any sign of life from Judge Jones?
Well, we talked last week about this additional briefing that Judge Jones ordered. He asked the parties after Mark Meadows testified to basically write a brief on whether, if some of the conduct that's alleged in the indictment is within the scope of Mark Meadows' duties as chief of staff, would that be sufficient to trigger removal? So the parties briefed that issue. They quite expectedly, Fani Willis said, no, that's not sufficient to remove. And then Mark Meadows said, yes, it is sufficient to remove. And we haven't heard from Judge Jones since. So, however, I will say some of these folks who are trying to remove, including David Schaefer, Jeffrey Clark, Mark Meadows, they've all filed these motions to try to, they've framed them in various ways, but the basic gist of these motions is they're asking the state court judge to stay the proceedings in state court. Mark Meadows has also filed a motion to sever his case on grounds that, if the case is removed, it might bring all of the defendants into federal court. So he tells the judge, you might as well sever me now, because then that way, if my case gets removed, it's just me. So there's a lot of kind of maneuvering in state court, but we haven't heard anything from Judge Jones yet. And we still have these hearings coming up on the 18th and 20th for the other people, Sean Still, David Schaefer, Jeffrey Clark, Kathy Latham. So we still have all of those hearings coming up. And I don't know if Judge Jones will decide before then or not.
Yeah, so a couple things. One is, one person who has not filed for removal is Donald Trump. Do we have a sense of why not? Is he just waiting to see what happens with Meadows?
Well, so he has 30 days after arraignment until he has to file for removal. He did file a notice today that was quite odd, because I jumped to the docket when I got a notification saying that there was an alert. It said notice of removal. And I was like, oh, Trump's removed. So I went to the docket, but the way that they framed it was this is an initial notice to inform the court that we may seek to remove Mr. Trump's case. So they're telling the court this, I think, because of the pending motions to sever and the question of whether or not he should be tried starting in October. But they noted that they have until 30 days after arraignment to make this decision on whether or not to remove. And I think you're right, Ben, that what they're doing is just biding their time and waiting to see if Mark Meadows is going to get removed, and they'll try to ride his coattails basically into federal court. If he does get removed, they'll make the argument that the whole action, the whole case should go with him. So, and then if he doesn't get removed, they'll make their own attempt.
So it seems to me like Mark Meadows' case for removal is noticeably better than everybody else's. So with Trump, the same acts as Meadows claims. Meadows says, hey, my job was to set up calls and do stuff for the president. I did that. When the president then has those calls, you get to ask the question, was it the president's job to have that call? But Meadows seems to me to have a better argument than Trump that, hey, my job was to facilitate what the president was trying to do. And then, like Jeffrey Clark was being told by his superiors, you're not allowed to do this. So he was like going rogue at the Justice Department. It seems like kind of chutzpahdik to defy the attorney general and try to get the attorney general fired so that you can be attorney general and do what you want to do, and then claim you were acting within the scope of your responsibilities. Like, since when is the scope of your responsibility to get your boss fired so that you can do the things that he won't let you do? Is there anyone in your judgment who has a removal? I think, as you know, I think Meadows' removal motion is relatively strong and I maybe should prevail, but I'm not sure I think that of anybody else. Is there anybody else who has a removal motion as compelling as Meadows?
Not that I can think of. Roger, do you have opinions on this? Because I'm in agreement with you, Ben.
No, I agree. And I liked Meadows. He had a clever argument, which is, he's in all of these awful meetings, which are hard to justify in terms of what's the federal purpose here. But he says, well, I'm chief of staff. My job is to make sure that I keep his schedule. He's got to leave that meeting by 5 p.m. So I'm there to make sure the meeting ends by 5 p.m., and yeah, well, that's sort of his job. And he doesn't seem to participate very.
Right.
I think part of the reason his claim is powerful is also that the case against him doesn't seem to be as powerful as against other people. There's a lot of just preparing phone calls. He does say some things during the big phone call on January 2nd or 3rd, whichever date it is, to Raffensperger, but not much. But so it's mixed in with the fact that the case against him isn't that strong. It doesn't, I haven't seen the case. Doesn't sound that strong just reading the indictment.
Well, and it's notable that he is not listed as a unindicted co-conspirator in the comparable federal case, and this may be part of the reason why.
I just also I do think it's important that they get this right, these removal things, because if we know one thing about the current Republican Party, it's that there are people in it, very powerful people, that believe very strongly in tit for tat and have no judgment and have no moral compass. And it is very likely, if they're considering impeachment now, they're considering how can we indict somebody in a small state court jurisdiction that goes our way. And we want, this is an important area. The law needs to be right here.
I think a lot of people's knees jerked on the on the removal question because Trump or Meadows was asking for it and Fani Willis was opposing it. But I actually, and Anna and Alan Rosenstein and I wrote this morning in Lawfare, I actually think the case for having the federal immunity questions decided by a federal court in the first instance is decidedly not a crazy thing. And I would not be at all surprised or disappointed to see Judge Jones say, at least for federal immunity purposes, we're going to consider that in federal court. And frankly, having now spent a little bit more time, which is not to say a lot of time, but a little bit more time with the young slime life case than a healthy person should do, which is another RICO case now in its 8th month of jury selection in Fulton County Court. I am not at all certain that old slime life case wouldn't have a better time getting to trial in the Northern District of Georgia. Can we call it OLS?
Yeah. Oh, OSL?
OSL, yeah.
OSL.
Old
That's
slime
a good
life.
one. Old slime life.
Yeah, Charlie Sykes came up with that this morning on the Bulwark. I thought it was good. All right, we are going to go to audience questions momentarily, but before we do, Roger, while you were away on vacation, it always happens when you go away on vacation, the issue that you spotted years ago as this is going to be big and it's going to be a problem for Trump in 2024, which was old Section 3 of the 14th Amendment, came bursting back with this article by Will Bode and Paulson, and then Mike Ludig and Larry Tribe. Everybody's jumping on the bandwagon that you have been not on, but eyeing for a number of years now. And now there's litigation in Colorado over it. So tell us everything we need to know about the Colorado litigation. And is it going to be named for you?
Yeah, so yesterday, I think, the CREW, which is Citizens for Responsibility and Ethics in Washington, they filed a case in the state court it's called the District Court of the City and County of Denver. And it's on behalf of 6 eligible Colorado voters versus Jenna Griswold, who's the Secretary of State, and Trump. Griswold is actually a Democrat, but apparently the implication is that they have asked her to keep Trump off the ballot there, and she has declined. And the suit is to force her to enjoin her to keep Trump off the ballot as disqualified under Section 3 of the 14th Amendment. And they've been obviously planning this for a long time. They had led CREW had led a case that successfully ousted the county commissioner, Coy Griffin, in New Mexico under Section 3 of the 14th Amendment. I think it's the only successful case so far since...
Your correspondent, Coy Griffin.
Yeah. Head
your
of the...
email bud.
Head of Texans for Trump, or I think. And he was a misdemeanor defendant convicted in January 6th. But that plowed some ground, and I think they were going to rely on that. And then, meantime, I don't know if they knew this was coming down the pike, but this rather huge article by Will Bode and Michael Stokes Paulson, who are these luminaries among originalists. They have quite a good reputation as originalist scholars. That's why this matters, what they think. Came out with this.
Will Bode is also a perfectly lovely person, just a genuine mensch of a human being.
And Michael Paulson might be too, but we don't really know him.
Yeah, I'm not casting any aspersions on Michael Paulson. I don't know him. I've known Will for years and think very highly of him. I'm sure Michael Paulson's love of his fellow human out Gandhi's Gandhi.
So, and procedurally, the case is something like the cases that were brought against early on last year against Madison Cawthorn, trying to keep him off the ballot in North Carolina, and one against Marjorie Taylor Greene, trying to keep her off the ballot in Georgia. And procedurally, those cases were a little stronger because those states provide very explicit procedures whereby citizens or electors, meaning voters, eligible voters, can try to challenge the qualifications of candidates. And so they had very specific procedures to follow. It looks fairly strong here, but it's not quite as strong. There is a cause of action where an eligible voter can challenge what state officials are doing in the realm of elections, and there's some case law suggesting that the Secretary of State does have a duty to ensure that the candidates on the ballot are qualified. So that's the basis. It's a 105-page complaint. It's exceedingly thorough. It reads something like the House Select Committee report. There isn't much left out. So,
and is the theory of it, as you understand it, that you get him struck in Colorado and then the Supreme Court will step in, the Supreme Court of the United States will step in and you litigate Section 3 there? Or is the theory that you get him struck in Colorado and then maybe he's not on the ballot in Colorado and then you do it in another state and you kind of do it until you have a conflict between state Supreme Courts that the Supreme Court will step in to resolve?
Well, those are good questions. I haven't spoken to the lawyers. I don't believe they would discuss that with me, but either of those results is a good one as far as they're concerned. So my assumption is either or.
Win in Colorado and then see what happens next.
Yeah.
All right. We are going to go to audience questions. Rachel, you get the first question today.
So earlier you were referring to the triangle of people involved, with the top being Trump and the bottom being a lot of these soldier type people. And the middle people you referred to as the Georgia currently indicted type people. But I was wondering about the Congress members. One was known to give a tour, I believe, the day before. One, I think, let someone know where Nancy Pelosi's office was. I think 6 asked for pardons preemptively. So I'm curious about what you guys feel about where those people should stand.
So it's an interesting question, and we know that the D.C. Circuit Court of Appeals this week issued an opinion with respect to one of the members of Congress, Scott Perry, who played a somewhat direct role in that he is the person who introduced Jeffrey Clark to President Trump and suggested what became the Clark, decapitation strike at the Justice Department. Scott Perry's phone was seized by the Justice Department, and the D.C. Circuit has now ruled that we don't know exactly what, because the opinion is under seal, but that there is some problem with the seizure under the speech and debate clause, and so has sent the case back to the lower court for a review of that. That opinion was issued by an uncharacteristically conservative panel of the D.C. Circuit, so you may see an en banc review of that, just a guess. But all of that is a long-winded way of saying that members of Congress have certain abilities to make certain arguments that are not available to the general public or members of the executive branch. and particular will use the speech and debate clause as a bit of a club, a defensive shield that is not available to anyone else. And at least in the case of Scott Perry, it's proving to be a pretty powerful shield. No member of Congress is named as an unindicted co-conspirator in the federal case. No member is named in the Georgia case. And I look at that. I'd be curious if Roger or Anna, either of you disagree. I look at that as evidence that some of the investigative threads involving members of Congress did not pan out quite the way some people expected. And I also note in the same regard that the January 6th committee ultimately decided not to spend a lot of energy going after, House members who didn't cooperate or whatever. And so my working assumption is that members don't have that much exposure, with the possible exception of Scott Perry. But I don't feel confident about that, and I'm not at all certain that I'm right. I'll leave it there, and if either of you have thoughts, chime in.
Those are my same hunches, that the speech and debate clause has thrown a wrench into the investigation, and then there are also tit for tat issues that do you want to really go there? And now obviously Fani Willis did look into Lindsey Graham, and maybe it turned out he was pure as driven snow, or
just that he talked so much. He was like, just get out. Do
yeah.
whatever you want. I just don't want to hear your voice anymore.
Yeah. So, but all I have is hunches, and my hunches are sort of the same as yours.
Michael, the floor is yours.
I finally understood from your discussion earlier why Mr. Cheeseborough would want to go quickly with his trial, to separate himself off, a limited set of charges, if I understood you, and it might go well for him in that context. And I've always understood from everything you all say why Mr. Trump would like everything to take as long as possible in order to run up into the election and the whole thing just gets snarled up in some way or other. But I haven't understood what the thinking would be about everybody else, the other 17, 18, and how they would choose to go quickly or not quickly. And the more I listened to you, I assumed, aren't they all afraid of being caught up as a group and looking like this racketeering group, as it were? And that's a risk for all these other people, but maybe not.
Yeah. So look, I think that point is extremely perceptive, and why, given suspects or indictees, defendants are going to choose different strategies for how to handle a case like this is to a great degree a creature of attorney strategic instinct and the way different attorneys will strategize it. For some of the big ones, you can make pretty broad brush assumptions. So if you're Rudy Giuliani, you've got I think the technical term is a shit ton of exposure in a case like this, and you're walking the streets right now. You're not locked up. Push it off as long as you can, right? And that probably goes for some of the other big name people as well. Similarly, there are some people involved in this case who were accused in a way that's, by the way, not true of, this case gets down and dirty with some pretty low grade local criminal activity, computer intrusions, breaking into a election office and stealing all the computer data, knocking on election workers' doors to terrorize them. I mean, this is some basic low-grade criminality that is pretty familiar to, they're not the only ones of cases like this in Fulton County Court. Let's put it that way. It's, stuff that county court systems deal with. And again, if you're walking the streets, and you're not necessarily looking to go to trial quickly. You may know that when you go to trial, you're likely to get convicted. You may also know that you're not going to go to trial. You'll plead your way out of it when the opportunity presents. So the longer you can put it off, the better from a lot of different point of views. There are also defendants whose defenses are dependent to some degree on Trump's goodwill, and those people are going to not, be kind of loath to make an argument. Don't try me with the former president; he'll sully me, right? Which you might otherwise expect would be a viable argument, but is not an argument that you're going to want to make if you're, going hat in hand to Mar-a-Lago for support. And I'm thinking particularly of, Anna's friend Kathy Latham and company. They're really dependent on Trump World for goodwill. They're actually actively raising money for their defenses. And you don't want to stick your thumb in the president's eye if you're going to his base and asking for money for your defense. So I think there's a lot of different reasons why people may want to go forward quickly. And by the way, Chesborough's and Powell's examples are different. I don't know why she wants to go forward. It may be because she's nuts. Chesborough, I think, and I was pretty impressed with his lawyers yesterday. I thought they made a bad case very well, and I encourage people to, what was his name? Grubman, Scott Grubman. He looked like he just got off of his Harley. He looked, like he just traded a big leather jacket for a coat and tie. He made an excellent set of arguments. I thought he was terrific. And I think they've just made the calculation that standing on his own, Kenneth Chesborough looks like a guy, as Roger said, who studied Hawaii, not a guy who got engaged in a criminal enterprise, and that they're better off with, being tried by himself and as quickly as possible. And I'm just not sure there are others that are in that position.
Just in a nutshell, that the conventional wisdom is if you're not incarcerated, delay helps the defendant. Memories fade, witnesses die. The burden is on the prosecution, so all of that is in your favor.
All right, so a couple of people who want me to ask for them. Simon asks, speaking of the missing middle part of the pyramid in the existing prosecutions, who should we suspect is missing from the list of those charged to date for January 6th related activity? Roger Stone, Steve Bannon, Peter Navarro, or others? So I will just start by saying there are 6 unindicted co-conspirators in the January 6th federal case. They would be numbers 1 through 6 on my list. I also think it is interesting that Mark Meadows has not been charged or named in that indictment, and I don't know how to read that. Roger, Anna, who are your top few?
Well, I will say, I think that in respect, if you're including Fulton County, I do in the January 6th universe of criminal cases. I think we might learn tomorrow who some people who didn't get indicted, and maybe are cooperating, which will be interesting because the special grand jury report is coming out at 10 a.m. It's scheduled for release. That is the report that the grand jury that investigated for several months and then recommended indictments. We might learn, that there are some people who were recommended and then made deals. We do know that there's at least 8 of the fake electors who made such deals, but there could be more. So I think that's going to be very interesting. I'm not sure if that really answers your question about who could potentially be indicted in the future, but I just am flagging that because we didn't talk about it, and it's something that's happening tomorrow morning.
Roger, who whose indictment are you braying for?
Can we consult with defamation counsel before I answer that?
We can use initials.
I'll tell you the people that I'm most interested in learning what role they might have or have not played. One is that co-conspirator 6, or we don't know if it's 6, Boris Epstein. I'm interested in him. I'm interested in Bannon. I just don't know that the others I'm sort are fading. Stone and Alex Jones and Ali Alexander. I don't think that's going to reach a criminal level, but we'll see.
All right. Anonymous attendee has 2 points. The first, not a question, but I knew Mike Paulson when I lived in Minnesota, and he's a super guy. So we now have a character reference for Mike Paulson as well as for Will Bode. All jokes aside, it's a very serious piece of law scholarship, certainly the most comprehensive document on along with Gerald Magliotta's original piece, on which it builds in important ways. These are the two most significant documents on the meaning of Section 3 in the contemporary era. Magliotta's, interestingly, was written before any of this came up. He just got interested in Section 3. Sometimes, you do academic historical work on the Constitution and life catches up with you. Roger, were you going to say something?
Yeah, in fact, I think that piece came out in December 2020, and so that was good timing. And but also Mark Graber has done some good work on this as well. And of course, he was the expert. He's a constitutional scholar, I think University of Maryland, and he was the expert in the Coy Griffin case for Crew. So we might see him again.
All right, so anonymous attendee also asks, if Chesbrough suggests a crazy idea for getting fake electors, how is that not joining the conspiracy? In what other contexts might that be a relevant idea? Roger and I may have slightly different answers to this. We both posed this in different ways. I'll just speak for myself. People write all the time loony or semi-loony legal theories based on past precedent and send them to campaigns for their use. And so one of Chesborough's lawyers mentioned...
That's how Bill Barr became Attorney General, in fact.
Yes. And, one of Chesborough's lawyers rightly pointed out that Larry Lessig and Van Jones wrote a CNN article when it looked like Pennsylvania might flip to Trump, suggesting basically an alternate electors slate for Biden. And so, this idea has been around since 1960 when it actually was done in Hawaii. And it certainly isn't a crime to merely float the idea, right? Or else we'd be right. So the question is, what more is there that Chesbrough did? And there are a variety of possible answers to that question. But I think without more, if all he did is write a couple memos suggesting the Democrats did this in Hawaii in 1960, we should do it to cover our asses in these states now, I would certainly be uncomfortable with that being a crime without more. That's just speaking for myself. Roger, do you have additional thoughts on that?
No, that's basically it. With Chesbrough, it's all contingent on facts. I don't know about how they're going to prove that this was a pretext, and he knew it was part of a scheme.
Anna?
I mean, I think I disagree. It's not like with a conspiracy, you have to show that there's an actual agreement or active decision to join a conspiracy, right? it's much more it's much more about showing that you were a part of the enterprise, that there was a common plan or purpose. But it's not like people just, you show conspiracy by saying, oh, Ken Chesbrough said in this memo that he was joining you know what I mean? It's not.
But a common plan
Yeah.
requires that you show, right? Certainly they had a common plan to get Donald Trump elected. And
Right.
The theory of the indictment is that they had also had a common plan once Donald Trump was not elected to get him installed as president again, notwithstanding the fact that he had lost. And the question, I think, to show that Chesbrough had joined the conspiracy, you would have to show that he was aware that this was a way of getting around the fact that they lost, rather than merely that he was like, well, we should preserve our legal options here.
Yeah, and I think that's right. But I think that where I'm just a little bit more, it's unclear to me what's not in the indictment in terms of what they're going to admit into evidence and show about Chesbrough's conduct. You would think it would be a mistake to not put some of the more damning things in the indictment, but I don't know. I maybe they have some more cards up their sleeve that we just don't know about yet. And so I'm just not sure that we can say right now whether or not they're going to have a more difficult time or not.
Absolutely agreed. All I'm saying is I totally understand why Chesbrough wants to be tried quickly and on his own.
Yeah.
Shannon asks, I've been watching the Eastman disbarment hearing. He continues to say the election was basically stolen when they show him documentation that the things he said are not true. He just says he didn't read it thoroughly or not at all. Is this a valid defense he will be able to use in Georgia? Also, is anyone at Lawfare watching the Eastman disbarment hearing? They are presenting lots of evidence that I think may be used in D.C. and Georgia, and would love to hear your take. So I'm going to leave the whether it's a valid defense to Anna. I will just say, yes, Quinta Jurecic has been following all the disbarment proceedings closely and has a lot of thoughts about the Eastman hearings. She is obviously not here today, but has been on others talking about them and will be in the future. So bring your Eastman questions to Quinta. Anna, what do you think? Does I didn't read the stuff that didn't support my view, and I believed the stuff uncritically that did, and therefore I acted in good faith. Does that get Eastman off the hook in Georgia?
I mean, I don't think so, but it might be part of some kind of defense. And this is just, I'd have to look into the case law and that kind of thing. So this is just me, speaking off the cuff, but it might go to some kind of mistake of fact defense. So Eastman saying, I truly did believe that the election had been stolen, and I, was doing all of this, believe in the belief that, all of these things were lawful because I believe there had been fraud and all of that kind of thing. Does that make sense? It sounds like it probably wouldn't work, but Ben, Roger, do you guys have other thoughts how this could play into his defense?
Well, I mean, I think it's more of a fact question for the jury. I mean,
bingo.
And even if I know there is some sort of defense in Georgia that you're referring to, but still the jury is entitled to say, oh, I get it, you're a liar. This is very convenient. And that's what jurors often do when people are saying very, very unlikely things and saying that, black is white and I really believed it. And I think it's a jury question.
I agree with that completely. John, the floor is yours.
Thanks, Ben. So maybe I've missed it, but why is the Young Slime Life jury selection taking so long? Like, what's actually going on, and does that have implications for the length of Trump's jury selection? I can't imagine it's hard to find jurors who have never heard of this guy, because I certainly hadn't.
Yeah, you don't live in Fulton County.
Yeah, I mean, it's a lot of people in Fulton County have heard of Young Thug and Young Slime Life, which is a record label, but then is also an alleged criminal gang called Young Stoner Life. Or maybe I'm getting that mixed up, where the record label is Young Stoner Life and the...
I think I'm going to change my name to Middle-Aged Lawfare Life.
Anyway, so to answer your question, John, which is a really good question that a lot of people have been asking, it's taking so long because the case it started out with 20 something defendants. It's now people have been severed out, and now it's down to, I think it's 13 or maybe 12 now. But, it's estimated to be the longest trial in Georgia history. It'll take over 6 months with potentially 300 witnesses to be called. And before that reason, they're having a lot of trouble finding jurors who are willing to be on the jury. So virtually every juror has claimed hardship, and the judge has to hear those hardships. So they can just not find 12 people who, because of various life circumstances, work or family or whatever, they just can't find 12 people who can actually be on a jury for potentially a year. That's a long time to be only paid $25 a day. So it's very hard for them to find those people who can do it. A lot of people don't like the high profile nature of the case. So that's taken up a lot of time. You also have to consider the fact that in Georgia courts, and I think this is different in federal court, but correct me if I'm wrong, the judge typically conducts voir dire. Is that right in federal court? Like asking jury questions, whereas in Georgia, defense counsel can, ask questions of the jurors and do their own voir dire questions. So when you have that many defendants and everybody is asking, wants their chance at asking questions and has different interests, and so it just takes a long time to get through this process. So hopefully that answers your question as in terms of what's going on, but we're in month 8 of jury selection in the YSL case, and they're nowhere near finding a jury yet. So we'll see.
All right. So the last question is from Jacob, and this wraps us up nicely. Do we know what court arguments are coming up in the various cases? So short answer, Anna, what do we have coming up in Fulton County?
So as I said, we've got these removal hearings that are happening September 18th and September 20th. That's on the fake elector removal actions, Kathy Latham, David Schaefer, and Sean Still. And then we've also got Jeffrey Clark. And then we have all these severance motions that are about the group as a whole. So we might have another hearing or argument on that. And the district attorney's office will be submitting further briefing on Tuesday about how removal plays into the severance aspect of it all. And then we also have David Schaefer asked for a hearing today because he claims that he had improper contact from Special Prosecutor Nathan Wade. That is the prosecutor who is in private practice, but was brought into the district attorney's office to conduct this investigation. I saw the exhibit that David Schaefer attached to his filing. It looks like one of those automated mass mailing that that defense attorneys send out to anyone who is recently indicted. And David Schaefer happened to get one from Nathan Wade's law partner. So now he's claiming that this is, an improper communication, and he's asked for a hearing on it. So those are the things that are coming up in the Fulton County case.
And what do we have coming up in Tanya Chutkin's courtroom? Do we know?
I don't. In the short term, there's been a flurry of sealed filings, actually in both the DC case and the Mar-a-Lago case. But in the DC case, I think it's pretty clear from a recent filing that at least some of them relate to Trump's quote, daily extrajudicial statements that threaten to prejudice the jury pool in this case. The government wanted to file something quickly under seal, and Judge Chutkan granted that, and then Trump's people moved to vacate that and said, you didn't give us 14 days to respond to their motion to file under seal, which is what sort of the default setting for the local criminal rules. And she actually decided, okay, she vacated, and then she gave them a much shorter period of time in which to oppose. But that might be sort of an interesting thing going on. And then we also saw today that I'm blanking on Casey Gannon at CNN, who's the woman who most follows the grand juries in D.C. She noticed that the D.C. January 6th grand jury was back in session after several weeks of dormancy. So I don't know if that has something to do with the the sealed filings, but that's sort of interesting as well.
Yeah. Also watch those unindicted co-conspirators.
Yeah. And then over in the Mar-a-Lago, if there's litigation going on about conflicts, whether Stanley Woodward, who represents a lot of witnesses, has conflicts. He represents Nauta. He also, by the way, represents Navarro, who was convicted today. But he represented, for a while, Yusel Taveras, who was Trump employee number 4, and who is now cooperating. And then there's a John Irving, I think, who represents De Oliveira. He represented 3 other witnesses who are going to be government witnesses, and the government was bent out of shape about that. They've gotten new lawyers since they filed their motion. Anyway, there's a lot of interesting litigation there, and simmering, beneath it all is the big question about, Save America PAC is paying for all these people's defense, and defense costs a lot. And so it's very hard to abandon Trump if you would have to pay for your own lawyers. And in fact, Nauta, I correct me if I'm wrong, but Nauta's salary is paid by Save America PAC, which is a really weird thing. So I think the government is trying to get at some of these issues, and it'll be interesting to see how Judge Cannon responds and how the government responds to how Judge Cannon responds.
We are going to leave it there. Anna Bauer, Roger Parloff, you are both great Americans. There is going to be a great deal more action over the next few weeks, and we will be here every Thursday at 4 o'clock Eastern Time. We will be back next week. Thank you all. The Lawfare podcast is produced in cooperation with the Brookings Institution. To join future episodes live of Trump's Trials and Tribulations, become a material supporter of Lawfare at lawfaremedia.org/support. Our audio engineers this episode were Kara Schillen of Goat Rodeo and Anna Hickey of Lawfare. Folks, share this on whatever social media service you use. Rate us on whatever podcast catcher you grabbed us from. And also, click that like button on YouTube on the episode of this show. If you watched it on YouTube, they all help, all those likes. The Lawfare podcast is edited by Jen Patja Howell. Our music is performed by Sophia Yan. And as always, thanks for listening.